Estate debt resolution. If you've been named as an executor and you're worried about being responsible for someone else's debts, I want to start by putting your mind at ease. Hi, I'm Terry Peterson, certified probate expert, senior real estate specialist, and founder of St. Louis Family Resources. As a realtor and investor, I help St. Louis families navigate these exact concerns every day. The number one thing I want you to understand is this: you are not personally responsible for your loved one's debts. The estate pays these debts, not you. But as executor, you do have specific responsibilities for handling them properly, and that's what we're going to talk about today. Section 1: not all debts are valid. Before you start writing checks to every creditor who contacts you, understand that not every claimed debt is legitimate. Unfortunately, some people try to take advantage of grieving families. I've seen fake collection notices, debts that were already paid, and organizations with poor record keeping sending outdated bills. Your first job is verification. Don't assume every bill that arrives is valid. Ask for documentation, check the deceased person's records, and remember, legitimate creditors should be able to provide proof. Section 2: time limits protect you. Here's something many executors don't realize. In the state of Missouri, a creditor has 6 months from the first publication of the legal notice to file a claim against the estate. However, if a personal representative mailed a notice directly to the creditor, they only have 2 months from the date of the mailing to file, whichever's later. Miss this deadline, the debt is legally barred. Understand this 6 month period does not extend other applicable statutes of limitations. There's also a 1 year overall limitation after the date of decedent's death for certain claims. This isn't about being unfair to creditors. It's about creating closure for families. You can't settle an estate if debts keep appearing indefinitely. Section 3: the priority system. Not all debts are equal. Missouri law requires debts to be paid in a specific order. First, funeral expenses. Second, estate administration costs, including legal fees. Third, taxes, both federal and state. Fourth, everything else: credit cards, medical bills, personal loans. This priority system protects what matters most while ensuring the estate is settled fairly. Now, Section 4: when the money runs out. If the estate owes more than it's worth, called insolvent, you're not expected to work miracles. The law recognizes this reality. Pay debts in priority order. Pay what you can with the available funds, and the remaining debt simply isn't paid. Surviving family members are not responsible for unpaid debts, with rare exceptions involving jointly held debts. Section 5: tax exception. While you're not personally liable for most debts, taxes are different. If you distribute estate assets knowing there are unpaid taxes, you could become personally responsible for those tax debts up to the amount that you distributed. This is why I always recommend working with a qualified tax professional and ensuring that all tax obligations are resolved before making distributions. If you need a referral to a CPA in the St. Louis area, please give me a call. We work with some of the top CPAs in the market. Section 6: negotiation tips. Many creditors would rather receive something than nothing. When estates are tight on funds, don't be afraid to negotiate. Credit card companies, medical providers, and other creditors often accept reduced payments. Get any debt forgiveness agreements in writing and be aware that forgiven debt may be taxable income to the estate. Number 7, important mistakes to avoid. Do not pay claims too early. Wait until the creditor claim period expires before paying non-priority claims. Do not ignore claims. Always respond to claims on time, even if you intend to deny them. Do not pay heirs first. You may not distribute assets to heirs until all debts and claims are properly handled. Paying claims incorrectly can make you personally liable for the estate's debts. Managing creditor claims correctly protects the estate and protects you from legal action later. When in doubt, review the claim with your attorney before paying or rejecting. Now let's bring this together. Remember, being an executor doesn't mean you have to become an expert in probate law overnight. It means you're responsible for ensuring the right professionals handle their respective areas while you make the important decisions. If you're dealing with estate debts that involve real estate assets here in St. Louis area, I'm here to help. Check out the resources on my website at stlouisfamilyresources.com and don't hesitate to reach out. Your loved one chose you as an executor because they trusted your judgment. Trust yourself to handle this responsibility with the support you need. Thanks for watching. If this helped clarify things for you, please give it a thumbs up and subscribe for more practical probate guidance. And remember, you've got this. Thanks for watching and take care.